Hello students, myself Dr. Harpreet Kaur and I will be discussing the topic of refugee rights. Introducing the topic, human rights of refugees are one of the major problems of the world. According to Article 1 of United Nations Convention on Status of Refugees, refugees are those who are owing to a well-founded fear of being prosecuted for a reason of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable or owing to such fear is unwilling to avail himself of the protection of that country. India has one of the largest refugee population in the world. Regardless of the fact that India serves to the diverse group of refugees, for example, Syrians, Afghans, Palestinians, Persians, Ethiopians and Christians etc., the country does not have specific domestic law and policies for the refugees. Although India is not the party to 1951 Refugee Conventions or its 1967 protocol, even does not have a national refugee protection framework, but still it continues to give asylum to refugees of the neighborhood countries. Asylum seekers can get the refugee status from UNHCR if the status is not protected by the Indian government. According to the Universal Declaration of Human Rights, states have a duty to protect the inherent dignity and worth and dignity of every human being, thereby including those of refugee and asylum seeker. The principle of non-refoulement also ensures that lives of asylum seekers are not put in danger by pushing them back into the countries where they face persecutions. Even states which are not signatory to the conventions are not outside the purview of the mandate to fulfill the basic right of refugees, as these rights have acquired customary nature. There has been development of refugee jurisprudence, wherein not only the rights of political refugees are to be protected of refugees covered under Convention of 1951, but even those who are forced to leave on other grounds like economic deprivation. This is due to the development of protection of economic, social and cultural rights as part of human rights, first under Universal Declaration of Human Rights 1948, followed by enforceable conventions under International Covenant on Economic, Social and Cultural Rights. Originally, ICESC was not considered binding, and it was according to the capacity of the state that the provisions required to be enforced. However, human rights interpretation tends to include economic, social and cultural rights along with civil and political rights. States today cannot refuse equal rights to all groups based on economic or social limitation of states. India has followed a liberal policy of humanitarian protection of refugees and asylum seekers. It is home to several groups of people who have come here and made it their home. However, the absence of a refugee-specific legislation can be attributed to India's volatile situation in South Asian politics and the threat of terrorism faced by it. Even in such absence of specific law, India has addressed the need of refugees who have fled from their home country into the territory. Meaning of term refugees. The term refugees has been particular meaning in international law, and its legal definition is laid down in the United Nations 1951 Convention relating to the status of refugees and its 1967 protocol. Article 1, Para 2 of the 1951 Convention defines the term refugee as a person who, owing to well-founded fear of being persecuted for reason of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable or owing to such fear unwilling to avail himself of the protection of that country. It should be appreciated that a person becomes a refugee because of circumstances which are beyond that person's control, often poignant. He or she is left with no other option but to flee from human rights violation, socio-economic and political insecurity, generalized violence, civil war or ethnic strife, all these leading to fear of persecution. Thus, it may be noted that there are well defined and specific grounds which have to be satisfied before a person can qualify to be a refugee. These grounds are well founded on the fear of persecution and consideration of a number of factors which may operate individually or collectively. Refugees are considered under the term alien in India. The term appears in the Constitution of India, Article 22, Section 83 of Indian Civil Procedure Code, Section 3, Clause 2, Subclause B of Indian Citizenship Act 1955, as well as some other statutes. Status of refugees in India. A brief look at the refugee scenario in India will help appreciate in the proper perspective the complexity of law enforcement in a variety of situations impining upon the refugees. India has been home to refugees for centuries, from time when almost the entire Zoroastrian community took refuge in India, fleeing from the persecution they were then subjected to on religious grounds in Iran. India has from time to time continued to receive a large number of refugees from different countries, not necessarily from the neighboring country alone. The most significant thing which deserves to be taken note of is that there has not been a single occasion of any refugee originating from the Indian soil, except the transboundary movement of people during the partition of the country in 1947. On the other hand, it has invariably been a receiving country and in the process enlarging its multicultural and multi-ethnic fabric. In keeping with its secular policies, India has been the home to refugees belonging to all religion and sect. It is relevant to point out that since its independence, India has received refugees not only from some of its neighboring countries, but distant countries like Afghanistan, Iran, Iraq, Somalia, Sudan and Uganda. Problem faced by the refugees in India. Various countries protect their refugees by enacting refugee legislation based on international recognized principle. The countries that have signed the convention have a procedure for identifying the refugees and addressing them, protecting the issue. Although India has not signed the convention but are providing protection to refugees. However, consistency in the procedure for determining refugees is still lacking. Since India has no uniform code for determining refugee status, there is no central body that deals with the refugees. After so many years also, there are various gaps that exist in the mechanism for dealing with refugees policy. This is because the government has not enacted a law for refugees. Due to the several problems faced by the refugees and no proper legislation has not been made, the legal status of the refugees is miserable. Problems Rohingyas are facing in India. There are reported complaints, open drains, unsanitary surroundings and slum-like conditions in the Rohingya camps across India. Few children have been dead due to pneumonia during winter winds. Snakes make a regular appearance during rains, as so do outbreak of dengue, diarrhea and other diseases. Some women refugees have reported instances of harassment. The deporting announcements by Union government also made the community anxious. Now coming to the constitutional provisions for the protection of refugees. Constitution of India are applicable to refugees when they are in India. The most important article is Article 21, which deals with right to life and personal liberty. It applies to everyone, irrespective of whether they are citizens of India. Many judgments have been given based on Article 21 on refugees. Article 14 guarantees the person right to equality before law. Article 5, 6, 7, 8, 9, 10, 11, 12, 20, 22, 25, Article 28, 32 and Article 226 also available for non-citizens of India including refugees. Treatment given to the asylum people were divided into three heads: national treatment, treatment that is accorded to foreigners, special treatment, national treatment. The national treatment to the asylum people is same as the citizen of India. There are certain articles in the Constitution of India which take care of the fundamental rights of all people in India. The rights such as equal protection to law under Article 14, religious freedom under Article 25, the right to life and personal liberty under Article 21, the right to social security and educational rights are guaranteed in Part 3 of the Constitution. Under this head, there are rights which are related to the housing problem movements, etc. The rights which are provided under this treatment are the right to employment or profession under Article 17, freedom of residence and movement under Article 26, right to housing under Article 21, right to form association under Article 15 and right to property under Article 13 of the 1951 Refugee Convention. Special treatment. This treatment includes the identity and travel document under Article 28, exemption from penalties under Article 3 Clause 1 of the 1951 Refugee Convention. In the case of Lewis D. Reddit versus Union of India, the court held that the fundamental rights to life, liberty, dignity are available to non-citizens of India. In case of Visakha versus State of Rajasthan, the court has held that international convention and norms are significant for the purpose of interpretation of the guarantee of gender equality, right to work with human dignity in Article 14, 15, 19 Clause 1 Subclause G and 21 of the Constitution, and safeguard against sexual harassment implicit therein. Now discussing the law for refugees in India. India does not have specific laws regarding the refugees. However, India does not have Refugee and Asylum Protection Bill of 2019, but the main legislation that supports refugee and asylum is the Foreigner Act of 1946. The laws related to refugees are Citizenship Act 1955, Extradition Act 1962, Foreigner Act 1946 and the Indian Penal Code Act of 1860, Passport Act of 1920, Passport Act of 1967, Protection of Human Right Act of 1993, Registration of Foreigner Right Act of 1939, Immigration Expulsion from Assam Act of 1950, Administration of Evacuee Property Act 1950 and the Refugee and Asylum Bill of 2019. Now coming to the legislative gap warranting the need for refugee laws for Indian citizens. The topic of refugee law is essentially neglected in India. Indian lawmakers and administration often confuse refugees with illegal immigrations, and it leads to legislative gaps in Indian refugee law as a whole. India is not a party to 1951 UN Refugee Convention and is therefore not bound by the 1967 protocol as well. India only grants the Foreigners Act 1946, Passport Act of 1967, Extradition Act of 1962 and Illegal Migrant Determination by Tribunal Act of 1983, which can be roughly called to be a refugee law. Under all these refugee laws, refugees are treated as foreigners who shall enter India voluntarily without any external force such as war. The recent amendment to the Citizenship Act of 2019 provides a broader aspect to the issue, but deals with it based on religion only. The Indian Constitution provides for several safeguarding provisions for foreigners, where foreigners along with Indian citizens are guaranteed the right to life under Article 21 of the Constitution of India. The Supreme Court of India has passed several historical judgments concerning the deportation of refugees, such as the case of Maiwand's Trust of Afghan Human Freedom versus State of Punjab and N.D. Pancholi versus State of Punjab and others. Apart from the feeble legal framework and the Supreme Court's humanitarian consideration about refugee, India does not have any special legal framework that deals with refugee as a class and view the issue of refugees as a human right issue that need special geopolitical, civil and economical attention. Further, the lack of distinction between the term foreigner and refugee under the Indian legal framework essentially points out how refugees are not viewed as a part of human right violation, where the acts of the refugees are involuntarily. Therefore, substantial clarity on the plight of refugee must be sought by the legislator and the judiciary. They need to have a system that acknowledges refugee individually and collectively is of utmost importance. Coming to a critical review of existing laws in India for refugees. Indian law do not distinguish between a foreigner who is voluntarily entering the border of India and refugees who are forced to take shelter within India due to external reasons such as war. The Indian legal framework does not shed any light on the topic of asylum, and it does not consider refugee as a class but a single individual. It can be seen from the current applicable laws of refugees. Indian legal framework essentially considers illegal immigrants and refugees under the same category, and as such refugees are not provided with any special political or legal shade. The recent event of Rohingyas in India shows how India lacks in providing better legal enactment for refugees. Further, if the existing legal framework is critically reviewed, it can be seen that the Indian law does not consider the human right paradigm of refugees, and no such provisions have been mentioned under the existing laws that guarantee the security of lives of the refugees. Hence, it can be assumed that the current existing laws of India are mere skeletons. Coming further to the role of judiciary for the protection of refugees. Judiciary plays a vital role in protecting refugees. Many cases gave landmark judgments regarding the refugees. The judiciary has made it easy with the concept of social action litigation and public interest litigation. When any of the refugees are detained or arrested by the Indian authorities, there would always be a danger of refoulement, repatriate or deportation. Those refugees who are arrested for the illegal stay can be detained illegally under administrative order without charges. The Foreigners Act vests an absolute and unfettered discretion in the central government to expel foreigners from India. The Supreme Court of India in Hans Muller of Nuremberg versus Superintendent Presidency gave absolute and unfettered power to the government to throw out the foreigner. The said judgment was upheld by the Supreme Court in Louis D. Reddit and others versus Union of India. In the same judgment, the Supreme Court also held that foreigners have the right to be heard. In the judgment of Qatar Abbas Habib Al Kutif versus Union of India, the High Court of Gujarat held that the principle of non-refoulement avoids ejection of a displaced person where his life or freedom would be undermined by virtue of his race, religion, nationality, enrollment of a specific social gathering or political conclusion. Its application ensures life and freedom of a person irrespectively of his nationality. Non-refoulement and right to refugee status in Malavika Karilkar versus Union of India. The deportation order issued against 21 Burmese refugees was stayed by the Supreme Court and allowed them to seek refugee status under UNHCR. Supreme Court on refugees. The Supreme Court has taken recourse to Article 21 of the Constitution in the absence of legislation to regulate and justify the stay of refugee in India. In NHRC versus State of Arunachal Pradesh, the government of Arunachal Pradesh was asked to perform the duty of safeguarding the life, health and well-being of Chakmas residing in the state, and that their application for citizenship should be forwarded to the authorities concerned and not withheld. In various other cases, it was held that refugees should not be subjected to detention or deportation and that they are entitled to approach the UN High Commissioner for grant of refugee status. In P. Nidumran versus Union of India, the need for voluntary nature of repatriation was emphasized upon, and the court held that UNHCR, being a world agency, was to ascertain the voluntariness of the refugee, and hence it was not upon the court to consider whether consent was voluntary. Similarly, according to B. S. Chimney, the Supreme Court has erred in concluding in Lewis D. Reddit versus Union of India that there is no provision in the Constitution fettering the absolute and unlimited power of the government to expel foreigners under the Foreigners Act of 1946. With regard to adopting international convention in domestic laws, in Vishakha versus State of Rajasthan, the court observed that reliance can be placed in international laws. Therefore, the question that arises is whether India can refer to 1951 convention in interpreting the domestic legislation and whether it is really necessary to ratify these conventions. It is to be noted that merely ratifying the 1951 convention does not ensure that the asylum seekers will not be kept out, and also Article 42 of the same convention permits reservation with respect to the rights of refugees, which will defeat the purpose of ratifying the convention. In the recent case where around 40,000 refugees have come to India from Myanmar, the government, on the basis of national security and threat of terrorist elements entering through this route, refused to give refugee status. The Supreme Court in Muhammad Salimullah and others versus Union of India and others, while deciding whether the government could deport the Rohingya refugee as minority. Concluding the topic, in the whole world, though there are number of conventions and laws governing the refugees still keep facing the problem. When a country as big as India doesn't have a refugee law, we can understand that many countries have the same phase and are on the same boat. There is definitely a need for India to set up a law regarding refugees, and in future there may be many more issues due to various reasons. Though protection to refugees is given under various articles of the Constitution, there is a need to be a uniform law that give equal rights to all the refugees. Many judgments in India support the refugees. India has done a very good work regarding refugees, but need to do much more. Many Rohingya refugees living in India are receiving support, but India is planning to deport them to their territory. The absence of a specific domestic law and ad hoc asylum status management might take away its soft power, robbing it of the credibility in international arena in spite of accommodating so many group of refugees even before the international rule of refugees were developed. Lack of a strong political will also among the chief concern. The issue of illegal migrations becoming important during election when political parties can take advantage of these groups. India being one of the developing country and a deserving candidate for the permanent member of the UN need to make its law in compliance with the international regime. This is because even without the municipal law, India is inundated with refugee influx from different countries, and it has more than often dealt with the refugee issue very humanly. Tibetan and Sri Lankan refugee being good examples. Migration is continuing to grow and the reasons are varied. It is time India adopted law to deal with the issues so that there is a transparency in administrative action. The process of deciding who is a refugee is also unclear. While the Indian government deals with asylum seeker from the Tibet and Sri Lanka, the office of UNHCR in New Delhi deals with asylum seeker from other countries. So, there is a need for greater coordination between the Indian government and UNHCR. Thank you and have a nice day.